May it please the Court, my name is Dickinson, D-I-C-K-I-N-S-O-N, initial M, and I appear for the plaintiff. Your Honour, I have two submissions. Submission 1. The plaintiff is not in contravention of Section 18 of the Australian Consumer Law, Schedule 2, the Competition and Consumer Act 2010, and has not deceived or misled the defendant. Submission 2. The plaintiff is not liable for Papa's fit-out costs. Submission 1. The contract has had a restrictive covenant referring to the hanger heights as per CASA Manual of Standards, Chapter 139. Additionally, the plaintiff explained the hanger heights must take into account the final level of the lot. The statement indicates that no level has yet been finalised, nominated, or promised. My client stated that Lot 2 is about 30 metres from the edge of the strip. The use of this word about relates to the exact, does not relate to an exact nor specific distance. Without an actual distance, site level, an implied or expressed specific hanger height is not attainable. Similar to Borman Barport 2018 BSC 291, that a plaintiff sold a lot of with a restrictive covenant in reference to height limitations. The court stated if a covenant makes reference to a specific building height limit, it must be adhered to. The levelling work performed by the defendant was not contractual, but a gesture and not a finished floor level, nor that any specific heights would be met. The defendant had the opportunity to perform additional sidewalks and did not. In Bourne, the court stated it would be too onerous to find such a duty in order to truly know the height of a lot. This is the work of a surveyor at the expense of the purchaser. The work was not part of any contract, nor paid for, and was ad hoc. The work by the plaintiff does not absolve any or all of the defendant's responsibilities. On the 8th of September 2018, my client sent the defendant all the relevant documentations, including the current survey level. At this point, the defendant had the opportunity to raise concerns that he may have, but he did not. Miller & Associates Insurance Broking Proprietary Limited and BMW Finance Limited 2010 HCA 31. The court stated the defendant had received the policy, its officers could have read and understood it or sought advice upon it if they were so minded. BMW was the author of its own misfortune. The court further clarified that if the information provided by the defendant was inconsistent with early material, it was for the defendant to evaluate or to seek further information. The same opportunity was afforded to the defendant. The defendant failed to read the documents provided, proceeded with the contract. The defendant is the author of its own misfortune. The plaintiff has not misled or deceived the defendant by remaining silent. In Bourne, the court applied the but-for test. The vendor had informed the purchaser earlier it may have halted construction and reduced the loss of the purchaser. However, this does not entitle the purchaser to relief. The court went further in stating it would be unduly onerous and contrary to impose the burden of monitoring compliance on the vendor. The situation that the purchaser found himself in was entirely of his own making. Actual misleading and deceptive conduct is best illustrated in the Henjo Proprietary Limited, Collins Marrickville Proprietary Limited, 1988, FCA 40. The judge found that Henjo, the vendor, owed a duty to inform the purchaser before the sale was effected as to the true position that this duty was breached. The case is not applicable to the current situation, as no incorrect information was given. All information was disclosed to the defendant prior to settlement. The defendant just chose not to read. Submission 2. Your Honour, the defendant is claiming payment for Papa's fit-out costs. A fit-out that the defendant was going to proceed with, regardless of discussions with my client. The defendant has not been put in a position of detriment, which is one of the elements of estoppel. This position is held in Thompson and Palmer, 1933, 49 CLR 507, where the court held an estoppel by the fact in itself that a state of affairs has been assumed on the basis of an action, and that a departure from this assumption would in turn the action into a detriment change of position. The court went on to state a person will not be stopped from departing from an assumption or representation, unless as a result of adopting it as the basis of action, the other party will have placed himself in a position of material disadvantage if departure from the assumption were permitted. The defendant has not suffered any material disadvantage. Otto Partners Limited and Belanda, 1989 FC, Queensland FC Court held, it will be insufficient detriment if the plaintiff merely spent money that he or she was always planning to spend. Papa always had the intention to complete the fit out and is not in a detrimental change of position. In Commonwealth of Australia and Verwain, 1990, 170 CLR 394, Chief Justice Mason clarified that while detriment in the broader sense is required in order to found an estoppel, and it would be strange to grant relief if such detriment was absent. Any detriment to the defendant is absent. Morton Stores Limited and Ma 1988 164 CLR 387, the court stated, to establish equitable estoppel, it is necessary for the plaintiff to prove the element. The fifth element being the plaintiff's action will occasion detriment if the assumption or expectation is not fulfilled. This is in complete contrast to the defendant's position. Additionally, Your Honour, Crown Melbourne Limited and Cosmopolitan Hotel Proprietary Limited, 2016 HCA 26, debated the meaning of looked after at renewal time. The court held that these words are not capable of conveying to a reasonable person that the tenant would have offered or a further lease due to ambiguous nature. The defendant proceeded on different grounds and performed alternate fit-out works, showing that the understanding was ambiguous between both parties. It's apparent that there was no meeting of the minds. Your Honour, in any order to reimburse the defendant would be creating a detriment to my client, as this would demand payment for an ambiguous statement. As seen in the list of cases, ambiguity will not be relied upon. The defendant was attempting to use my client as a blank cheque for his works, for works he was already planning to do prior to contract. Your Honour, in submission, the defendant's failure to read the contract and to understand the height limitations is so severe it amounts to careless disregard for his own interests. The defendant is the sole architect of his own misfortune. The defendant, Papa, has not incurred any detriment, which is an element of estoppel which must be met. Additionally, the defendant proceeded with the fit-out on ambiguous terms. In light of the submission, my client should not be held liable for the fit-out costs nor misleading or deceptive conduct claims. May it please the Court, if Your Honour has no further questions, these are the end of our submissions. Thank you.